You're facing weapons charges in Oklahoma, and you have no idea what's coming next. You were booked, given a court date, and sent on your way. But that silence is dangerous, because weapons cases can spiral fast if you don't handle the first steps correctly. Most people don't. They panic, talk too much, plead early, or rely on bad advice, and end up with a conviction they never saw coming. In this video, I'm going to walk you through what really happens after weapons charge in Oklahoma, where people go wrong, and how to protect yourself before the damage is done. I'm John Cannon. I run a criminal defense firm here in Oklahoma, and I've helped hundreds of clients fight serious weapon charges. This video breaks down how these cases are handled in the real world, what mistakes to avoid, what defenses hold up, and what to do early if you want to protect your record. Understanding weapon charges in Oklahoma. Let's get right into it. If you or someone you love is facing a weapons charge in Oklahoma, you're probably scared, overwhelmed, and searching for hope. The good news, there are proven ways you can fight back. But before we fight, we need to know exactly what you're up against. Weapons charges in Oklahoma cover a wide range of situations. You might be looking at illegal possession of a firearm, carrying a weapon without a license, using a weapon while committing another crime, or even possessing a gun where you aren't allowed to, like schools, airports, or on a military base. Each of these comes with its own challenges, but there are common strategies that work across the board. Before we dive in, remember, every case is different. What works for one person might not work for another. If you're facing a weapons charge, talk to an experienced Oklahoma criminal defense attorney as soon as possible. Now, let's walk through the steps you can take to beat a weapons charge and protect your better future. Challenge the stop and search. This step is hands down one of the most effective ways to fight a weapons charge in Oklahoma. Here's why. Just because the police found a weapon, that doesn't mean you're automatically guilty. The police have to follow specific rules when they stop you, or search your home or car. If they mess up, the whole case could fall apart. Let's look at a real example. Imagine you're driving through Moore, and you get pulled over for crossing a lane line or a busted taillight. The officer starts asking if he can search your car. You say no, but the officer searches anyways and finds a handgun under the seat. If your lawyer can show the officer had no real reason to search your car, no probable cause, no exigency, then anything the officer finds can be thrown out in court. It's called suppression of evidence, and it happens more often than you think. I recently represented a client charged in federal court after being arrested following a warrantless search of his vehicle. At the suppression hearing, we showed the traffic stop was pretextual. The officer stopped my client based on appearance rather than a legitimate traffic violation. The court agreed, suppressed the evidence obtained from the search, and without the evidence, his federal case was dismissed. Oklahoma law and the U.S. Constitution both say police can't just stop and search anyone based upon a hunch. They need to have what's called a reasonable suspicion to stop you and probable cause to search. If they don't, the evidence falls apart. Bottom line, if you're stopped or searched without a good legal reason, your Oklahoma criminal defense attorney can fight to get that evidence thrown out. No evidence, no case. Prove lack of knowledge or intent. The next powerful defense is showing that you didn't know about the weapon or never intended to break the law. This comes up most often in cases where the weapon wasn't found on your person, but somewhere else, like in your car, your backpack, or even your home. Let me give you a scenario I see often around Tinker Air Force Base in Midwest City. You're driving your own truck onto base, maybe for work or a quick errand, and you simply forget that you had a firearm in your vehicle. You're stopped at the gate, the weapon is discovered, and suddenly you're facing federal firearm charges, even though there was no intent to bring a gun onto federal property. Here's the critical point. Under federal law, possession generally requires knowledge. The government still has the burden to prove you knowingly possessed the firearm on base. If you genuinely forgot it was there, that becomes a central issue in the case. Your attorney's job is to challenge whether the government can prove knowledge beyond a reasonable doubt, because accidental possession and knowingly possession are not the same thing under the law. This also applies if someone else stashed a weapon in your house or car without telling you. Maybe you had a roommate or a friend riding with you. If the weapon wasn't yours and you didn't know it was there, you may have a strong defense, especially if your lawyer can capture the testimony of the person that put the gun there. The key is being completely honest with your attorney from the very beginning. Explain who owned the vehicle, who had access to it, and how the firearm may have ended up there. If the facts support a legitimate lack of knowledge, your lawyer can challenge whether the government can prove knowingly possessing the firearm beyond a reasonable doubt. 4. Attack the possession element. This one sounds technical, but it's actually simple. In Oklahoma, the prosecutor has to prove you actually possessed the weapon. That doesn't always mean they found it in your hand or in your pocket, physical possession. In fact, possession can mean you had care, custody, or control over the weapon, i.e., constructive possession. Let's say you're at a party in Oklahoma, police burst in looking for someone else and spot a gun under a couch. There are 10 people in the room. Just being present near the weapon is not enough for the conviction. The state has to prove that you had control over or access to the weapon. When a firearm is accessible to multiple people and ownership or control isn't clear, the prosecution's case can break down quickly. We see this all the time, people being charged just because they were near a weapon. But proximity doesn't equal possession. Remember, presence at the scene of the crime does not equal guilt. If you never touched it, and if other people had equal or better access, your lawyer can fight hard for dismissal of your gun case. This is exactly where an experienced criminal defense attorney goes to work. From the outset, we're trained to look for gaps in possession and proof. Who else had access to the weapon? Was it hidden or in plain view? Did anyone actually see you with it? Or is this case built on assumptions or what someone thinks they heard? The fewer facts that clearly tie you to the weapon, the more leverage your defense has. Challenge the type or status of the weapon. Many weapons cases fall apart because the firearm doesn't actually meet the legal definitions required for conviction. This is especially true in federal firearm cases under the National Firearms Act, NFA, including cases involving devices like a Glock switch or allegations involving short barrel rifles or shotguns. These charges only stick if the government can prove every technical element, and when it can't, the case weakens quickly. Suppose you're arrested for carrying what the police call an illegal switchblade, but after your attorney examines the weapon, it turns out it's just a spring-assisted knife, which isn't illegal under Oklahoma law. Or maybe the gun you're accused of carrying isn't actually functional. It doesn't fire and can't be easily repaired. Under state law, that might not count as a weapon for criminal purposes. Your lawyer can bring in experts to examine the weapon. If it doesn't match the law's definition of an illegal weapon, or if it isn't actually capable of being used as a weapon, that can be enough to beat your case. Sometimes police are confused on the law, or the law changes, and what seemed illegal at the time isn't actually a crime. Leverage your right to self-defense. Oklahoma is a state that takes self-defense seriously. Under the law, you have a right to protect yourself, your family, and your home. If you're carrying or using a weapon because you genuinely believed you were in danger, you may have a strong legal defense. Let's say someone threatened you or tried to break into your house. If you grabbed a weapon to defend yourself, your lawyer can argue that your actions were justified under Oklahoma's self-defense or stand your ground law, or the Castle Doctrine. These laws say that you're allowed to use reasonable force, including weapons, to protect yourself from harm or death. I've represented clients charged with murder and manslaughter, where the case never made it to trial because the court found their actions were legally justified. In one case, the evidence showed the client was confronted with a credible threat at his own home. We raised immunity under Oklahoma's self-defense and Castle Doctrine statutes, presented the facts at an immunity hearing, and the judge ruled that the prosecution could not move forward. Once the court found the use of force was justified, the case was dismissed. It's important to be honest about the situation. Did you have a real reason to be afraid? Were you in a place you were legally allowed to be? Did you use only as much force as needed to stop the threat? If so, self-defense could be your ticket to beating your charge. Even if you never fired the weapon or hurt anyone, just showing you had a credible threat can make a difference. And if you're defending yourself or others and follow the law, you should never be afraid to fight your charges in court. Police or prosecution mistakes. Some cases aren't decided by what happened, but by how the case was handled. Sometimes cases are resolved by closely examining whether every legal step was followed. Criminal cases can move quickly, and that means the details matter. In Oklahoma, charges have been dismissed when required procedures weren't completed, such as when Miranda warnings weren't properly given, evidence handling was incomplete, a weapon was never fully tested, or the wrong statute was applied. Here's a real-life example. In Oklahoma County, an officer charged someone with possessing a firearm as a felon, but failed to check if the person's old conviction qualified as a felony under Oklahoma law. The defense attorney caught the mistake, and the judge dismissed their case. Attention to details can make or break a firearm case. A good defense lawyer will review every piece of paperwork, every statement, and every report. If there's a mistake, we can use it to your advantage. Seek out alternative resolutions. Not every weapons charge needs to go to trial. There are times when the best way to beat the charge is to get it reduced or dismissed before it ever goes to jury. In Oklahoma, especially for first-time offenders or nonviolent cases, prosecutors may be open to alternative resolutions from prison. Some of these alternative options could include entering a diversion program, agreeing to counseling or attending classes, or working on a plea deal that doesn't leave you with a permanent criminal record or going to jail. Sometimes, if your attorney can show you've never been in trouble before or you had a valid reason for what happened, the prosecution may agree to drop the charges or reduce them to a lesser offense. It's not about giving up, it's about understanding all your options in order to protect your better future. Talk it over with your lawyer. Ask if there are pretrial diversion or deferred sentencing options. Sometimes getting your record cleared is just as important as beating the case at trial. Take action early and stay silent. Here's the part most people mess up. What you do right after getting charged can make or break your case. The less you say to the police or anyone else, the better. Don't talk about your case on the phone. Don't post about it on social media. And don't try to explain yourself to officers or friends. Stay calm, say less, and remember the golden rule: shut up and lawyer up. Call a criminal defense attorney in Oklahoma as early as possible. Timing matters. The sooner a lawyer is involved, the more options that are usually available to you. Before statements are locked in, evidence goes missing, or mistakes get baked into your case. Early counsel allows your attorney to preserve evidence, identify witnesses, and protect your rights from the very beginning. Remember, the police and prosecutors aren't on your side. Anything you say can be used against you. Let your lawyer do the talking for you and focus on what you can control. Let's review how you could potentially beat a weapons charge in Oklahoma. 1. Challenge the stop and the search. 2. Prove lack of knowledge or intent. 3. Attack the possession element. 4. Challenge the type or status of the weapon. 5. Leverage your right to self-defense. 6. Highlight police or prosecutor mistakes. 7. Seek out alternative resolutions. 8. Take action early and stay silent. Remember, every case is different, but these strategies reflect how weapons cases actually get dismissed under Oklahoma law. If you're facing a weapons charge, timing matters. Talking with the lawyer early, someone who understands Oklahoma law and the local courts, can make a real difference in how your case unfolds. And if this video is helpful, the next one is worth your time. How to get a felony theft case dismissed. It breaks down dismissal strategies that apply far beyond theft cases and can help you understand where leverage really comes from when you're facing serious criminal charges. That's where this continues, your better future.